This is Ed Kaminsky checking in here in Manhattan Beach, California. We're sitting today with Bill Weintraub from Elkins, Kalt, Weintraub, Rubin, and Gartside, a Century City law firm. And Bill, I thought it'd be interesting to have you here today and ask you a couple things about really the probate and trust world. But tell me briefly just about your firm. What is your firm's specialty?
Well, we do a number of things. We have about 35 lawyers. We do general real estate practice, which includes leasing, finance, joint ventures. We have a very substantial tax practice of which I'm involved. I do estate planning and transactional tax planning. We also do general corporate and business work as well as business litigation.
Okay, terrific. And so you focus on taxes, I know trusts and probate and those type of things, is that correct?
That's what I do.
You know, we hear the word probate a lot. You know, for those that don't understand it, I'm still surprised today how many things end up in probate. But can you just share with the people that are listening, what is probate?
Well, probate is something to avoid.
Okay.
Probate is a process by which assets that are held by an individual who died are transferred to their beneficiaries. So to take a simple case, if an individual owned a house, stocks and bonds, had bank accounts, and kept them all in their own name, and then died, and then directed under the terms of their will who would receive those assets, in order to transfer title, we have to go through the probate process so that we know that the assets are transferred to the appropriate beneficiary. So probate is a court-supervised process. It's public. The will has to be filed with the court, so everybody gets to see what's written in the will. All of the assets have to be placed on an inventory and filed with the court, so everybody gets to see what the assets are. And it's a very slow process that can take months or years, and it's also fairly expensive because there are statutory fees that apply to the transfer of assets in a probate proceeding.
Avoid probate is what I heard.
Avoid probate, that's what most of us try to do.
And how do you avoid probate?
Well, in general, the way to avoid probate is, instead of having all of your assets held in your own name and transferred upon death pursuant to the terms of your will, what most lawyers do in this field is to establish what's known as a living trust. A living trust is a trust that you can amend or change as you go along. It's really, as I describe to people, it's a dual-purpose document. It has all of the instructions that you would think of putting in a will that describes who gets the assets, when they get them, what the terms are, and who's in charge. But the dual purpose of the living trust is that during your lifetime, the trust can take title to your assets. So upon your death, the trust becomes fixed. It can't be amended. A new trustee steps in, reads the instructions of who's supposed to get the assets that are held by the trust, and since the assets are already in the trustee can very privately transfer those assets to the intended beneficiaries without the publicity and expense and delay and aggravation of probate.
So bottom line is, if it's in a trust, you're going to save money, you're going to save time, you're going to add privacy, and I assume have some tax savings as well.
Well, all of those except the tax savings, because in fairness, whatever tax planning we can do, we could do using just wills. So that's a common perception that you can save estate taxes using a living trust. Just the trust by itself doesn't result in any special tax savings.
Gotcha. We get the question a lot, how should I take title to the property? Joint tenants, tenants in common, what are your thoughts on that?
Well, it depends on the circumstances. If you're simply talking about a residential property, somebody buys a house, in general the best way to take title is in their names as trustees of their living trust.
Okay.
There's a big difference, however, if you're buying commercial or industrial property. And it gets to be very complicated dealing with the property tax rules under Prop 13. But as the short answer, if you're acquiring property, it's far better to acquire property in the name of an entity from day one, form an LLC or a partnership, as opposed to, if you and I, for example, were buying property, we could buy together as co-tenants and sometime in the future form an LLC and transfer to the LLC. But for property tax purposes, it would be far better for us. We would be able to avoid reassessment easily when we transfer our property down the generations if on day one we had acquired it in the name of an entity.
So if someone needs really good advice on how to take title, is it best to go speak to a lawyer like yourself?
Well, for residential property, I think most people have a general understanding. They don't necessarily need to seek the advice of a lawyer. If they have a living trust, people that already have trust have usually been educated and informed and know how to take title. If it's something that's not a residence and people are buying other property, or they just don't, if they've never had the experience, first of all, if they're going to take title in the name of a living trust, the first thing is they have to have a trust.
Right.
And there are a lot of people that don't have a trust. So it depends upon the circumstances.
If you give one piece of advice to people listening as it relates to real estate, law, trust, probate, anything, what advice could you give today?
Well, particularly in the estate planning world, because a lot of forms are available on the internet, forms that could work for some people, my key advice is don't view your estate plan documents, whether it's a will or a trust, as a commodity, as something that's just a form. You just fill out the blanks and it works. Because small mistakes that you make or things that you may not be aware of can create real problems for your family in the future. Not just with respect to potential tax issues, but really more importantly in terms of how the assets get to where they're supposed to go, how your beneficiaries deal with each other. There are a lot of problems that are created by lawyers who are general practitioners who draft documents without really understanding the nuance and complexity. And it's not that uncommon that a family will split apart because of bad lawyering or bad drafting in the document. So if you view it as a commodity and I can just fill in the blanks, it might work, but if there are substantial assets, you could create a lot of problems without knowing the questions to ask.
That's really great advice. Bill, one last question. If someone wanted to reach you, I don't know what your availability is, but if they did, what's the best way to get in touch with you?
Probably the best way would be to contact me in my office. My phone number is area code 310-746-4403, or they can contact you and you can pass them along from there.
That sounds great. We appreciate your time today.
Thank you very much.
This is Ed Kaminsky. We're checking out here at Manhattan Beach, California. You have a great day. We'll see you again soon.